I'd also like to discuss what it means to do a loan modification. At the end of your forbearance, if you have a balance with your lender and your lender is telling you you need to apply for a loan modification, it's very important to understand that you need to have documentable proof of income. If you simply go to your lender and state that you're not working or you're still on unemployment, there's a very high chance that your loan modification will be denied. If your loan modification is denied, your house may slip directly into the foreclosure process. The reason is because after the forbearance, you're going to have a several month balance with them. If you're not able to show that you're able to start making payments, even if it's a modified payment, which may be a lower payment or the same payment, the banks will tend to deny loan modifications and then proceed with whatever other legal remedy they have. Now, remember, a bank's legal remedy is taking your home. That's the collateral that you use when you promise to make your mortgage payments. If you're not making your mortgage payments, in California, the bank can only do one thing: take your home. They typically will not come after you personally. They will typically not come after you judiciously. That's why if you look up foreclosures, if you're doing some research online, you will see that California is a non-judicial foreclosure state, which simply means the banks are not going through the court system. They're not coming after you personally, but they are coming after the collateral which they have, which is your property. Now, there's a few ways to protect that property. The most common ways is through loan modification, different types of workout solutions, which also include forbearances, repayment plans, and things and debt settlement, things of that nature. If your loan modification or your negotiations with your lender is denied, there is one safeguard in place, which is a federal law called Chapter 13 bankruptcy. So, Chapter 13 bankruptcy also allows a homeowner to stay in their home because the Chapter 13, unlike a Chapter 7 bankruptcy, has a legal tool in it which allows you to get back current with your mortgage payment. So, if your lender is not going to work with you to stay in your home, we can force them through the bankruptcy courts to start accepting mortgage payments and putting together a workout or a reorganization of your debts to allow you to stay in your home. Our number one goal is to keep you in your home, but unfortunately, that goal does not always align with the way the mortgage companies will treat you. If the mortgage companies are giving you a hard time regarding a expired forbearance and a new balance based on the pandemic and loss of income or hardship, you need to contact an attorney, a local California attorney who knows California law, who can advocate for your case to make sure that you do not lose your home. Again, the options are working directly with the bank or filing a Chapter 13 bankruptcy. It's also very important to understand that some people who were delinquent before March of 2020, so that means that before the pandemic took hold of the United States and the world, you were already delinquent on your mortgage. You may not qualify for certain types of programs that people who just became delinquent on their mortgage in March 2020 would. The reason for that is the banks do not look kindly on people who were already delinquent before the pandemic. They basically look at that as you were already having a hardship, which was created not because of the pandemic. It may have been compounded because of the pandemic, but it was not created because of the pandemic. That creates a double layer of um, that creates a double layer of complexity and sort of a couple different potentials to hitting a dead end with your lender. A lot of this has to do with who services your loan. A lot of it has to do with who owns your loan. Remember, if your loan is owned by the government, you're going to have your best chance of success. If your loan is owned by a private banks still being the large banks, Citibank, Bank of America, Bank of New York, all these banks that we've all heard of, Chase, um, you have a better chance. And then you also have to be wary of privately held loans. When I use this word privately, capital privately, these are small lenders who are the most difficult to work with, who are the most aggressive when it comes to foreclosure. In those situations, those people will try to foreclose on you day or night unless they get every single cent you pay them. In those situations, it's very important to have an attorney to advocate for your rights as a homeowner in California.